And then this is Mr. Evans, and it is for review, and 380655525 on for review, and then on for arraignment is 480472552, 380820191, 480231898, and 380549215. And proceeding with the arraignment is your true and correct name, Sylvester Larnell Evans.
Sylvester Larnell Evans Jr.
And what is your date of birth? Earlier we went over your rights to arraignment. Any questions about your rights to arraignment that I wasn't able to answer?
No, I don't have any questions, but I would like to speak with the judge if possible.
You'll get it in a moment. So, Your Honor, I've gone over the charges, the maximum penalties, any mandatory minimum penalties. Would acknowledge the complaint, waive formal reading, ask them to plea of not guilty. And Mr. Evans will need to screen if you would like assistance from the public defender on these new cases.
Plea of not guilty will enter. I do find probable cause to, or let me just run through them. On the case ending in 319 is a review. Case ending in 215, probable cause was previously found on November 21st, 23. In the case ending in...
I didn't take part in...
Just a minute. 5525 is a review. The case ending in 898, probable cause was previously found on April 2nd, 24. The case ending in 191, probable cause was previously found on January 2nd, 24. And in the case ending in 552, probable cause was previously found on May 19th, yesterday. What is the city's recommendation regarding release?
The city is requesting bail or bond amount of $500 on each of the 6 cases. Defendant has a significant warrant failure to appear history, including 1 active warrant out of Tacoma Municipal Court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail or bond on the 2 review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption of administration of justice.
Any objection, Mr. Iannotti?
No,
Yes, ma'am. I would like to speak. I would like
Just a minute. I'm going to talk to your attorney for a second. And then if you want to say something and it's okay with your attorney, I'll hear it then.
Mr. Evans, I indicated that he did want to say stuff, and I told him he couldn't. He also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
Okay. All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appear, but if you give me a chance at a personal bond this time, I want to deliver a letter to you hand to hand. I will make the court date because I want to deliver a letter with a message to you hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where I'm getting mistreated. I'm on 23-hour lockdown. I'm on crutches. I have a leg injury, and it's extremely difficult and mentally strenuous, the things that they're doing to me inside of the jail. That's why I say I want to, if you give me a chance at a personal bond, I assure you I will appear with the letter in my hand for your insight, as well as attention to Chief Justice Roberts, so he can be alerted to what's going on. You have my word on that.
You have 17 warrants out of our court alone.
You have my word, Your Honor, that I will appear. I want to...
sir, with all due respect, you just don't come back. You have 17 prior warrants out of our court. It is your duty to keep your address updated. I think $500 each case is very reasonable. I can't
afford that at the moment. That's why I was asking for personal recognizance. If if you give me a chance, I assure you I will be there because I want to prove that I'm innocent of these charges and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can appear, I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg. And it's messing with the muscles and nerves because I need to keep my leg active and in motion. And they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal Court.
I'll resolve that as well, because when I went to court, they initially told me it was dismissed. So I guess they just put something back out. I'll resolve that as well. But if I humbly and respectfully ask that you please give me one chance to prove myself, please, because it's almost unbearable for me to represent myself and with my leg injury and the conditions they have me in and me getting mistreated in the jail as well.
Okay, I've made up my mind. I'm imposing bail in the amount of $500 each case. And I will appoint Mr. Ionati while you're in custody so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way.
Ma'am, that's the whole point I was trying to make. Mr. Ionetti is not properly represent me. That's why I want to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm not forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me. And I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many eyes that's gonna see it. In addition to that, the circumstances and the conditions they have me in is unfeasible. I'm in 23-hour lockdown. I'm in a cell to where there's no access to the kiosk where I can look at the law library. In addition to that, I'm in a
Mr. Ionati, when would you like to set this over till?
Thursday.
All right, Mr. Evans, we'll see you back here on Thursday.
Would I be able to request a PR bond at that time, or is everything?
No, you're only entitled to one bail hearing unless there's been a change in circumstances.
What about the jail conditions they have me in? I'm in 23-hour lockdown. I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Ionati while you're in custody, and or at the very least a standby counsel. You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ionetti give me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well?
Yes. you'll have
Well,
all-
you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Iannetti this, he never made any motions to get the process started. That's why
There is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself if
And that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll accept it.
it's gonna be extremely difficult to do that with the circumstances I'm in.
I can give you the information and go over what you need with you.
They have me in 23-hour
Okay,
lockdown.
thank you, Mr. Evans. We'll see you on Thursday.
And this is Mr. Evans.
Hello,
Your Honor, this is Sylvester Evans.
did you get the letter I mailed in, Your Honor?
I did not.
Is the court ready?
Yes.
Okay, I mailed the
One
letter.
second, Mr. Evans. So this is Sylvester Evans. It's 380312319, 480231898, 380655525, 380820191, 480472552, and 380549215. And I don't believe you were here, Your Honor, on Monday when Mr. Evans was arraigned. But Mr. Evans at that time indicated he wanted to represent himself, and he's also indicated that to me today. I did go over the waiver of attorney on pretrial and arraignment form with him, and explained it to him and talked about it. It sounds like when I spoke with him, because he's in custody right now, I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed, if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
Okay, and I believe Judge Brian did do the jail calendar on Monday. So did you say competency was raised? I didn't quite understand that piece.
Oh no, that I was talking about the other person. Veronica Johnson was who I started to talk about.
Got it.
And then when Mr. Evans walked in, I just said, we'll get to that when we're done with Mr. Evans.
Got it. Thank you. Thank you for the clarification. All right. So Mr. Evans, so we have not yet done the arraignment, right?
No, it was done
It's done. So
Sunday. And the city doesn't believe there's any change in circumstances, so would object to defendant's motion
I
to
guess
release or
I
adjust
just-
bail.
Oh, thank you, Ms. Chenoweth. I guess I just for my clarity, so this was on Monday and we set it again for today for what specifically?
Pre-trial and the
Oh,
tracking reviews.
okay,
Because the court set bail or bond, we set the pre-trials pretty quickly.
I
got
would
it.
like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I can honestly say I don't recall defendant mentioning the Native American part on Monday, but he did discuss the other thing in quite more length than he actually even is today. So the court did have that before it. Now, as far as the other piece that he's presenting today, I state's position is that doesn't change anything and there's no proof.
I sent the proof in the letter, that I mailed out.
Wasn't provided to the city. I haven't seen any proof. And I would say that's not a change in circumstances.
I mailed the letter out
What was said?
I mailed the letter out on Tuesday with the evidence, and the proof, invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file, in the federal courts, a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches, and it's affecting my leg. I broke my tibia and fibula in 5-6 different places, and the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
And Ms. Chenweller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fight history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport. We have 4 pre-trials and 2 reviews involving those allegations, the same allegations before the court today. Has warrant failure to history in pretty much every case.
What is his date of birth? I'm trying to find him on Jabs.
My last name is Evans, it's not Williams. And also, there's no evidence that I was trespassing. Each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday as well.
And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you. Can you please?
I'm not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America, the Supreme Court of the United States of America. And in the letter, I put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans. So I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case. Since I was not the judge on Monday, I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday. Additionally, we need to address the fact that you are requesting a waiver of right to an attorney. I will note that I don't believe that that is in your best interest. I think an attorney would be helpful to you. However, if that is what you would like to do, I want to make sure that you understand that you have one, two, three, four, and you have 4 cases that are pre-disposition, and it sounds as if you have 2 review matters, which means you've already entered into some sort of plea on those cases. But on your new cases, do you understand, Mr. Evans, that these are gross misdemeanors?
Yes, ma'am.
And you understand that with that, you could potentially serve up to 364 days in jail and or pay a fine of up to $5,000?
Yes, ma'am.
Okay, you understand that you do have a right to have an attorney, have a lawyer represent you in all stages of these proceedings. And if you cannot afford a lawyer, that you have the right to request a public defender,
Yes, Your Honor.
and that a public defender, if you qualify, will be appointed to represent you,
Yes, Your Honor.
and that you may be at a disadvantage if you proceed without a lawyer.
Yes, Your Honor. As I previously
Okay,
stated.
Mr. Evans, I heard everything that you had to say. I just need to make sure that you understand the rights and that you understand that you'll be required to follow all the laws of evidence and court rules which apply to this case. Do you
Yes, Your Honor.
understand that? And that these laws and rules can be technical and complex, and that you may not fully understand them without a lawyer.
Yes, Your Honor.
Okay, and that you realize that by proceeding as your own lawyer, if you do not represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received inadequate representation.
Yes, Your Honor.
And are you aware of the risks and disadvantages of proceeding without a lawyer?
Yes, Your Honor.
And knowing that you still choose to represent yourself, knowing the risks, you freely waive your right to be represented by an attorney.
Yes, Your Honor.
So you are waiving your right to be represented by an attorney.
Yes, Your Honor.
All right.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That could you please put on note that I asked that it be sealed immediately?
And again, Mr. Evans, those sort of things need to be done in writing to the court. Mr.
I
Iona, do
did.
you have any concerns about competency?
I do, but I'm hoping that if the court sets a hearing next week, I think either on Tuesday or Wednesday, perhaps that letter will have come in and it might answer.
Okay, so for right now, I did sign the waiver of attorney, but I am going to allow counsel to remain on standby. Let me see when's the next time we can. Wednesday, May 29th.
And also, Your Honor, I would like also to put on note that I mailed the letter off on a blank piece of paper and I numbered it. If it's kind of difficult to read, you might have to put something on each line because due to the circumstances, that's why I had to mail the letter off. I mailed the letter off. Because I was in a tank to where I didn't have access to anything. They had me in a restrictive tank while I'm on 23-hour lockdown. And I have no access to the law library or nothing.
All right, so we are setting these matters for May 29th at 11 a.m., all matters. If there's nothing else to address, this concludes this matter.
Just want to note for the record that the city is going to object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you have provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter off. I can rewrite it and remail it off, but I mailed the letter off. I definitely sent it off and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off and it should be on camera that I handed the letter to the guard.
All
The
right,
city's
well,
entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean,
I
if we're
mailed
setting
it.
it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street and I put on there to the clerk. I attentioned it to the clerk. So that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
no, we are not ready to address that today. So we will
Okay.
address these matters again on Wednesday, May 29th.
Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and
Yes.
will it be able to be reviewed by federal judges if it gets to that or whatnot? Okay, I can read a copy of the letter. I mailed the letter out. There's no reason it shouldn't have reached you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoked my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part, and the getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself, especially that I invoke my rights as a tribal chief.
I believe we've already had multiple bail hearings. I'm sorry, Madam Clerk, you were saying?
I was just going to say that there was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
I assure. If you look at the evidence that I submitted, I assure you I am.
I received no evidence. I received just your letter.
Right.
So I'm not going to. I'm not going to grant your motion to dismiss.
Okay.
What are we doing?
Okay. And I submitted evidence in the letter.
I'm not denying. I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter, and I'm not granting your motion to dismiss.
I understand.
Okay. What are we doing?
What about the evidence?
What do you want me to do with the I don't have any actual evidence. I have your statements.
Right. I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted, you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You have
is
to retrieve it.
I have no way to do that.
You have
That's
to
not your
contact the
job.
courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I ethically cannot do investigation on my own.
No, I'm not asking you to do an investigation.
You are. You're asking me to go retrieve something. That's an investigation.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you gonna be able to retrieve that case for me?
One second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The case has a seal on it, and you're gonna have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that in the letter I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain. And some of these cases are in review status. They've already been resolved and found guilty.
Okay, and also in those review cases, I said if the
Sir, I'd really like to focus on what we're doing today. I've denied your motion. We need to move on.
Yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress. Sir,
you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You got, Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions, so I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one? Okay.
I just clicked on it to give him an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
you have to file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like I don't have any access to the law library.
That's something you'll have to talk to SCORE about. So has any discovery been provided?
I gave him the narratives.
Police reports, that's it.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try if you're not going to agree to try them simultaneously. I can't guarantee you they'll all be tried we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means and the benefits and disadvantages of joinders.
So, Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them. Here's what I'm going to suggest then. I'll put this out to you guys. You tell me what you want to do. set them all in the June term. And then whichever one goes, but we'll have them all set so that it'll depend on who's available and such, okay? But they are not joined that unless somebody files a motion to actually hear it, but as of now, nothing is joined, okay?
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans. And a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operations airport so I can have those guys verify that I was there. The reason I was there is legal airport business.
Ms. Tinwaller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on
director
the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it. Not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why.
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
No, I'm saying that I was a customer of the airport.
It's
Correct.
not an affirmative defense. An affirmative defense would be saying I trespassed, but I had to because I was being chased by someone and I ran into the airport for safety. It was necessity is an affirmative defense.
Okay.
Lawful use of force is a defense.
In that
Just
case,
saying I didn't do it, I was allowed to be there is not an affirmative defense. It's a defense. I'm not saying that it's not a defense. I'm just saying it's not technically an affirmative defense such that you have to put the city on notice.
okay, according to your definition, I guess it's not an affirmative defense. But once again, could they close the door so I can make sure I'm hearing? Can I re-verify that everything is being recorded and that everything's on file? And I would also like that a court reporter be present for all future hearings and possibly for this one as well, if possible.
We will not have a court reporter. We are not required to. We are not a superior court. We don't have a budget for that. We record everything. Everything is recorded. But we do not have a court reporter. We do not have access to a court reporter, and I'm denying that request.
Yes, ma'am. And then also, could I file a motion to appeal that?
You have to actually file it. You don't need my permission to file a motion. You can just file it.
I mean, a notice to appeal, I'm sorry. So I would get that information from Mr. Ianetti because I don't have any access to the law library to get these motions or notice of.
Sir, you have to have a basis in law to request that. I can't imagine, we are not courts of record in that sense, like a superior court. We do not have court reporters.
I understand, but I feel my constitutional rights are being violated.
So there is a recording of everything. Everything can be recorded and transcribed, but we don't have a real-time court reporter.
Okay, what's the difference?
I can explain.
I'm ready, Your Honor.
Okay. And it looked to me like what is current speedy in custody, Ms. Chinweller, do you know?
719.
Thank you. All right, Mr. Evans, bail remains $500 each case. We'll see you back here, each count rather. We'll see you back here on June 12th at 11 o'clock in the morning. Stay in touch with Mr. Ainati. He can help you.
Ms. Judge, Your Honor, my bail was raised. Is there any explanation for my bail being raised? Some of my cases was $250. It went from $250. Yes, ma'am.
Oh, I'm sorry. You mean I just said that I changed it right now? I see that.
It was changed by the previous judge. It was raised to 500. She went just off the notion of what the lawyer said, which was inaccurate. And then the inaccuracy was passed on to you as well. And then you were about to redouble down on it.
All right. Thank you for pointing that out, sir. I'm restoring bail to $500 per case.
You mean $250 for some of the cases?
Well, it's $250 per count on cases that have 2 charges.
All right, let me take a look at the paperwork I got and I'll let you know which one said $250 bail.
Yes, Your Honor, I believe that the last hearing that it was pro tem judge and she set it at 500 per charge. And I think she misunderstood that when Ms. Chinweller advised her, it was supposed to be 500 per case.
Correct.
Okay, for a case ending in 2319, that was $250 bail.
No, see, there are 2 counts. Look down below it. There are 2 counts. There's 1 count of criminal trespass in the 1st degree and 1 count of making a false statement. Both of them are $250. It's 1 case.
Okay, so you combine the 2 charges and it comes up to 500. I got it.
Correct. So it's 500 per case, but I'm restoring it to that. I believe there was a Scribner's error in the last order. And I thank you for correcting me, Mr. Evans, or pointing that out. So it is now, so on the case, and similarly, the case ending in 525, that's the last case. There are 2 charges on that case as well, and it's $250 each charge. Okay. So then.
So was I right or wrong?
You were right. I mean, I put it back the way it was, 500 per case.
Okay, and I'll have trial for all 4 cases on the same day, or?
We can't possibly do all 4 in one day. We're good, but we're not that good.
Gotcha. So,
One second.
and also the letter that I sent you, it's going to be on file for the public to see all the information I have in there?
Until I receive a motion to seal and we have a hearing on it, yes.
Did you read the backside of it as well? What I
Yes.
said? Okay.
But sir, so this is why I'm encouraging you to look at the Bone Club case, because that sets out the criteria by which a court can seal a document. It's not, I can't just seal it because I feel like it or because you want it sealed. There has to be a justification.
It's a matter of national and homeland security.
You can't just say that. You have to show me why it is.
Because it's an investigation.
So again, you can't just say things. You have to, I need the whole story, not just little bits. And just so you're aware, we are streaming this hearing live on YouTube before you go any further than you want to.
Right. So my whole life is in danger at this moment because of this. I clearly wrote in a letter that I'm connected to an investigation that is a matter of national and homeland security.
But you can't just say that. You have to show me the whole thing. I can't just take your word for it that that's an issue. You're muted. You're muted.
I gave you the evidence to prove what I was saying as well.
But you didn't. You just said, I have this thing. You didn't, I don't have the thing. I need the thing.
I gave you the evidence in civil case 24012 out of St. James.
Okay,
Parish,
we're
Indiana.
circling, sir, we're just circling back to things. I do not have that case in front of me. You have to present that case to the court. You can't just say there is a case.
So I have to do it in a motion form, or do I have to, for me to physically get a copy of that, it's impossible for me to do it. My lawyer probably can do it, but it's impossible for me to do it from within inside.
I understand, and we had this discussion at the beginning of the hearing, and you've talked to Mr. Iannotti about that. I can't do any investigation. I am not your attorney. I'm the neutral party. I'm not the city. I'm not you. I will do no investigation. That would be, frankly, I could be sanctioned for doing that. It's up to you to present evidence to the court. It is not the court's job to find evidence.
Okay, in the letter I did present it as evidence.
It's not evidence. It is just claims.
All right, so I actually have to file an actual motion as evidence, and
It's not the motion. You have to file the evidence, the thing itself.
you mean the actual physical copy of the civil case?
Yes, that is exactly what I mean.
I don't have the actual copies of the civil case in front of me due to the fact that I would have to call the courts to get it. And I cannot do that from inside of this jail, and they will not fax that to me from the inside of this jail.
Okay, so we're having the same conversation over again. You can talk to Mr. Iannotti about this. But I can't, there's just a limit to what the court can do. All right, thank you, sir. We'll see you back here on June 12th.